For 2.5 years now, I've been the Independent Commissioner for Standards, responsible for dealing with complaints against Assembly members. As my annual report issued today indicates, during that 2.5 years, the picture in relation to the conduct of AMs has not been perfect, but neither has it been besmirched by the more serious allegations of fraud and abuse which have characterised other places. I do believe that in Wales there is now a well-nourished acceptance that standards are part of the culture and not an optional extra. It's trite to say, but nonetheless true, that with power comes responsibility. And as ever greater powers are devolved upon the National Assembly, so the responsibility of members to act in such a way as to demonstrate to the electorate the integrity, openness and transparency necessary to win and maintain their trust becomes ever more vital. My vision, and I hope it's not utopian, is for a National Assembly which sets standards that act as a beacon for public life in Wales. The well-known Nolan principles include leadership as one of those 7 principles, and what better place to set the standards than leading from the top. I had asked the presiding officer, Rosemary Butler, to participate at this event today, and she had kindly agreed to do so. But unfortunately, emergency business in this, the last week of sitting before recess, and I believe going on even as I speak, has forced her to withdraw. I'm extremely grateful, therefore, to the Chief Executive and Clerk to the National Assembly, Claire Clancy, for stepping into the breach and for agreeing to join in our question and answer session later. In a moment or two, I shall ask Lord Judge, the Lord Chief Justice of Wales, to give the inaugural Standard Commissioner's lecture. He's accompanied today by Lady Judge, to whom, of course, we also extend a very warm welcome to Wales. But they're no strangers to the Principality, ladies and gentlemen, far from it, as they spend as much leisure time as they can here. When I visited Lord Judge in his room in the Royal Courts of Justice in the Strand and asked him about his private connections with Wales, he lifted from his desk his coffee mug, held up the coaster to show me, and on the coaster was written, "I'd rather be in Abersoch." Lord Judge was appointed to the High Court 25 years ago. He rose through the Court of Appeal to the post of Lord Chief Justice, which he's held for the last 5 years. And in this capacity particularly, he has visited and sat regularly in Wales and has been a very strong supporter of our circuit, of our courts, and of our legal profession. I'm immensely grateful, Lord Judge, for the honour that you do me and the Assembly in coming to Cardiff to address us on this important topic, and I'm now delighted to invite you to do just that.
Commissioner, Chief Executive, ladies and gentlemen, in a way this is rather a sad moment for me. This is the last public lecture I shall be giving as Lord Chief Justice, and it is somehow fitting that I should be giving it here in Wales. When I was appointed Lord Chief Justice 5 years ago, the very first visit out of London that I made, and I made it within the first week, was to Wales. And this is my last visit out of London before I leave office. I'm not going to address the topic at all. I'm going to start by recognising or suggesting to you all that in my period of office, the development of what is sometimes described as legal Wales has been energetic, with something of an inexorable forward momentum of the tide when it is flowing, and by golly does it flow in North Wales. There is nowhere in the whole world where my wife and I go where I relax more quickly. You see, all these things that we do are frightfully important, desperately important. And I know that in 100 years' time I shall be gone, the decisions I have made will be of no importance, but the tide will come rolling in and rolling out, and that will be true in 1,000 years, 10,000, perhaps even 1,000,000. And so it is extraordinary how the pulse of the tide slows you down to a sense of reality. I've been proud to be associated with progress, and I have frequently said, and I shall repeat it to you, progress on these occasions ultimately depends on the votes of the citizens of Wales as expressed in the ballot box. How far devolution, and in consequence how far legal Wales will develop, is for the people of Wales. Where do they wish it to go? Where are they prepared to be persuaded for it to go? Where will they decide that they do not wish to go? Where are the lines that, for the time being, in their view, they wish to be drawn? All these questions and their consequences for public life in Wales, in every aspect of public life in Wales, depends on them. That is the reality. This is what we call democracy. It's democracy in action. The wishes of the minority not to be ignored. We don't have a tyranny of the majority. The wishes of the minority not to be ignored but respected, but ultimately the wishes of the majority will prevail. And of course, whatever those wishes may be now, they may not be the same 10 years or 20 years from now. And so in the democratic process, all these issues can be visited and revisited in accordance with the results in the ballot box. For the administration of justice in Wales, perhaps the most significant feature, partly but not exclusively, because of its impact on language issues and the impact of language issues on nationhood, is that in the courts in Wales, every litigant is entitled to use Welsh. It's not a matter of the discretion of the court to allow it. It is the absolute entitlement of the citizen. So it is his or her choice. That is not particularly complex or difficult and is readily understood. But it does have this further point, that the powers of the National Assembly for Wales have increased, and so that increasing numbers of the laws that bind those who live in Wales have become an ineradicable part of the law of Wales. And thus it is that these two apparently disparate routes are gradually meeting. What I'm driving at is this. Legal Wales is developing in its own way at the speed appropriate to the constitutional arrangements, and the judiciary in Wales is well aware of it. For this reason, as Lord Chief Justice of Wales, I have a Wales Committee of the Judges' Council, drawn from judges and tribunal judges at all levels of the judiciary in Wales, to advise me as Lord Chief Justice of Wales. The Judicial College, which is responsible for judicial training, has a specialist Wales Committee to address the issue of training of Welsh judges in, as it develops, Welsh law. The constitutional arrangements mean that as Lord Chief Justice I have meetings with the First Minister from time to time in exactly the same way as I meet the Lord Chancellor, Secretary of State for Justice in London. And I draw from my own personal experience of these considerations and seek to address the issues of standards of public life in Wales. For this reason, it seems to me that just as the issue of legal Wales is being addressed by those responsible for the administration of justice in Wales, for the people of Wales, the issues of standards in public life in Wales is a Wales issue. Of course, we all know that no one, you don't need a book to tell you this, that no one in a position of authority, whether political, civic, educational, health, any subject you care to think about, is going to be allowed to accept a bribe to achieve the result wanted by the person offering the bribe. I mean, this is all very elementary. And some of these standards are not a Wales issue at all. It's not an England issue, a Scotland issue, an Ireland issue. It's a universal issue in a civilized community. Some standards are completely immutable. Nevertheless, at this time, these first 2 decades of this century, it is perhaps worth the people of Wales and the National Assembly for Wales in particular to seek to ensure that standards in public life in Wales are not only the highest possible standard, which of course everybody wishes for, but may wish to reflect on how they should be achieved and protected in Wales for Wales. So what I am not doing, emphatically not doing, is coming here to tell you, assembled here, what should be done for Wales by Wales, but rather respectfully suggesting to you that the issues to be addressed by you in the Welsh context should be done by reflecting on two aspects of how we in the judiciary seek to ensure the highest possible standards for the judiciary in Wales. And let me again emphasise, I'm not making a political point, let alone a party political point, and what I'm saying isn't directed solely to the National Assembly for Wales, but to every single member of the community in Wales who has a position of responsibility. The headline is clear enough: standards in public life, the leadership of the National Assembly. But it applies to everyone in a position of authority. There are many with public responsibilities who serve our communities in Wales who are not political at all. If you like, the headmaster of a school, not political, a position of responsibility. The health trust, a position of responsibility. All people who are required to perform at necessary standards, and I would say the highest standards, of public life. And so the first and perhaps most important feature to underline is that in Wales the citizens are entitled to accept the highest possible standards of probity and integrity from us all. And in a sense that's dead easy, because that's what all of us in public life aspire to and want from our colleagues. But second, and this I do not think it is possible to overemphasize, second, whatever the truth may be about high standards in public life, it is an absolute imperative that the citizens of Wales should believe that these standards obtain. What I'm really driving at is this: although perception can often be wrong, perception is a fact. And if it is a fact, it impinges on public life and must be addressed. Let's just look at the perception that judges imposing sentences these days are soft, weak, wet. You think of the epithet you choose to apply, you read it in your daily newspapers every day of the week, and some of them are less polite than soft, weak, or wet, but we all know what they mean. Now, this is said at a time when over the last few years more defendants have been imprisoned for longer in the cases brought to justice before the courts than ever in our history. So what's the fact? What's the perception? Very many people, and this is a sad fact, very many people believe that we live in a lawless country, or an increasingly lawless country, in which crime is constantly on the increase. Yet, the story told by the crime figures, and I'm not using the political trick of bending a few figures this way to say crime's gone up, or bending them a few ways this way and say crime going down, the crime figures undoubtedly indicate the contrary. But if you're frightened that you're living in an increasingly lawless community, then you're frightened. Your perception may be wrong, but you are living with that perception and its consequences. And so your fear is based not on the fact, but on your perception. And this, ladies and gentlemen, why I do assert that perception is a crucial fact It's crucial to just about any aspect of public life, and therefore it is of huge significance to the issue of standards in public life. Dealing with it very generally, I suspect that some of the revelations relating to the expenses of MPs in London and so on, as well as a variety of different scandals that have been revealed by an independent press, may have led to a perception in the community that standards in public life have slipped, not just among the individual members of Parliament who made the extraordinary claims that some of them did, but all of them. They're all fixed with this perception. Well, if that is the perception, if standards have in fact slipped, they must be addressed. If they have not slipped, then the perception that they have slipped must be addressed. These are questions which at the stage of the development of Wales must be addressed by those in public life and those responsible for public life, and of course by the National Assembly for Wales. There is a sense in which Wales in this context must be saying to its citizens, even if your confidence in standards in public life outside Wales has been damaged, there is no reason to believe that standards of public life in Wales have been damaged. And if there have been examples where public life has been damaged, that leads on to this very difficult question: who is responsible? Obviously, the offender. And we'll come on to the development of this in a moment. But I want to get across to you that we have to work at this. You can't take it for granted. There are many things which we do take for granted, which we never should. We need to address how to ensure that the public retains confidence in the standards of those who run the country. We do live in a much less deferential time than our forefathers did, no problem with that. There are some among us who automatically think the worst. What a pity. There is undoubtedly an increasing degree of cynicism and suspicion. Any one member of Parliament making a dishonest claim for expenses damages our perception of our legislature. We must allay these suspicions. We must ask, request, cajole, encourage, persuade the National Assembly for Wales that it must be in the vanguard, not on its own, of course, but nevertheless leading. There's not much leadership in standing behind your troops. The Commissioner for Standards in Wales has a direct responsibility for the conduct of the members of the Assembly. I've read his recent report with great interest. It is clear that standards are very high. The Nolan principles underpin the Code of Conduct. There's no need for me to reiterate them. Many of them, as I said earlier, are perfectly obvious. No bribes, no inducements, proper register of interest, honest claims for expenses. Dare I say it, in view of some of the more troublesome features of the scandals in London, no claim for expenses. What was it? Decoy ducks on a moat, or videos, whether semi-pornographic or not. Nothing to do with pornography. If it's Walt Disney and Mickey Mouse, what on earth has that got to do with the performance of your functions or your spouse's functions as a member of Parliament? So where the standards are set, are clear, there's no problem, except occasionally when somebody says, what I did was in accordance with the standards, and the standards haven't moved to keep up with public perception that this particular way of behaving is unacceptable. The more difficult area, however, is this: where the rules are not specific, where they don't actually say anything at all. In short, where the Commissioner cannot say, well, on these facts, that is clear, plain, express misconduct. Do you mind if I approach this again by using my own responsibilities for judicial conduct as a means of conveying what I wish to? I get many complaints against judges, the vast majority of which are not sustained. Many of the complaints are that the judge has reached the wrong decision. Well, if he or she has reached the wrong decision, the issue can go on appeal to a higher court, and a decision is made. So the complaint that the decision is wrong is not a complaint about judicial misconduct. So we have to recognize that. There's the remedy. But then there are complaints that the judge has behaved in an unacceptable way. Bullying, saying things which give the impression of bias or prejudice, treating a vulnerable witness badly, laughing at a witness who's giving evidence about a delicate matter. Well, that's different. The answer the judge gives at the end of the case may be impeccable, no criticism at all. But the conduct, that sort of conduct, is justifiably open to a complaint. Then where do we go with the case of the part-time judge who's been declared bankrupt, or who has been convicted for driving on holiday one evening abroad with excess alcohol? These are not matters of conduct which have anything whatever to do with the way in which the judge has exercised his or her judicial responsibilities. Nothing at all. So in that sense, they're entirely personal or private. But most people, and for most people rather, they would be. I mean, if somebody not in a position of public life drinks and drives, it's a matter of embarrassment, it's in the papers, but that's it. But the two examples I have given you in the context of a judge provide examples where, to put it no higher, there would be a tendency, and a not unreasonable tendency, to diminish public confidence in the judiciary as a whole. Now let's apply these sorts of situations to those holding positions of responsibility, not as judges, but as members of the National Assembly. It's not quite, I think, an answer to say, well, these matters can be dealt with through the ballot box next time round. Of course, they can be dealt with by the citizens through the ballot box next time round, but even if the member were to be triumphantly returned 2 or 3 years later, there would have been damage to the standing of the body of which he or she is a member. We have to face the reality that with positions of responsibility comes publicity. In my world, even the most junior judge, even the part-time judge who's never sat for more than one day, is always headlined as top judge. That's the way of the world. Top judge in the newspaper headlines if involved in a road traffic accident. And so it is for everyone in public life. And so the public hears about matters which in reality would never see the light of day for citizens who are not in a position of public responsibility. But for those who are, any one of these stories has an impact. Now again, applying these sort of considerations to the National Assembly for Wales and everyone here in public life, I try to ensure that the Judicial Code of Conduct is constantly reviewed and updated, if only to take account of changes in public perception and the remarkable changes in our systems of communication. We do, of course, have constant self-imposed restrictions on behaviour, self-imposed by us as judges in the interests of the body, and that must be true, again, of anybody in public life. Like everyone else in this country, judges are entitled to have freedom of speech. Much blood was shed by our fathers, and some of you your grandfathers, and much grief shared by your mothers and some of you your grandmothers, in order to preserve that right. And we must not put it at risk. or allow the blood that was shed and the grief that was suffered to be cast away. So, freedom of speech is a basic right of every member of this country. It is what President Roosevelt called the first freedom. We can think, and nobody can stop what goes round in our head. It's speech, the freedom to speak, that is the first freedom provided for us by society. Nevertheless, judges cannot, they really cannot comment on their own cases. If they get a thrashing in the newspapers for a decision they've reached, they can't write to the newspapers and say that's a most unfair report, or even just read the transcript. Judges, unlike just about everyone else in this country, do not and must not publicly criticize political decisions or comment on politically controversial or potentially controversial political questions. We must keep ourselves above the political, well, perhaps above is the wrong word, but whether it's above or below, outside the political debate. That covers just about any potential legislation. There is very little legislation that every single member of the National Assembly will agree to, or every single member of the Parliament in London will agree to. And we cannot have, as judges, one political party claiming, oh good, the judges are on our side, and the other lot saying, oh good heavens, who do they think they are, getting themselves involved, and then, depending on the views we take, changing from time to time. This will diminish the standing of the judiciary in the public eye. It will diminish our independence in the long term. So, there is a bar on the exercise of freedom of speech. But it works the other way round. If we comment and legislation is passed, we then have to deal with the cases. And if we have commented in advance, then the parties are entitled to say, you're not fit to be a judge in this case, you're biased or prejudiced, or you've made up your mind. And that's a perfectly reasonable point of view for the litigant to take. There's a quid pro quo the other way, though. The same convention is supposed to apply to ministers, and on the whole, after a few hiccups when a new party comes into office, it does. Just as we do not comment on political issues, policies, and so on, which may become legislation, which we must eventually interpret, so they should not comment on our judicial decisions, whether they agree with them or not. There's no hurraying, no booing, at least there shouldn't be. They may, of course, ministers may, of course, indicate they'll appeal, fair enough, but there should be no personal comments about the judge or vituperative criticism. They needn't worry, there'll be plenty of that from other sources. Now, plenty of people will do that, but ministers should not. So, if I may just address this, bring it to an end, our constitutional arrangements involve mutual respect between judiciary and executive, each respecting their individual, the other's individual responsibilities. Public slanging is to nobody's advantage. And so, what's the answer? Freedom of speech, curtailed. Private life, my right to speak freely, any judge's right to speak freely. Private life, interfered with. But the interests of the institutions that we serve require some reduction of our personal rights. And that's the situation which has to apply when we're assessing the difficulties which face anybody in a position of responsibility. Is this private? If it's private, so what? Or is this private in a way which actually has, because of the job I do or the office I hold, an impact on the public perception of the way I am doing my job and the way in which my colleagues are doing their jobs, and may that perception be adverse to the organisation or institution that I serve? It's a constant question. It never goes away. It's there for everyone with a public office. Let me ask you a question, really. I'm not going to ask you to raise your hands, that would be rather insulting, but how many of us here in this very hall remember how new Facebook is, or Google, or Twitter? Things we take totally for granted. It's all less than 10 years old. It's all less than 10 years old. They were not with us 10 years ago, yet now they are all pervasive. The revolution in methods of communication is not going to slow down. I don't know, and I don't expect, with great respect to all of you, that any of you have the slightest idea of what communication systems will be providing us with 10 years from now, 20 years from now, the time when your grandchildren are a little older. Mine are a little older than most of yours. They do all their learning through a screen. They never open a book to learn. They open a book to read and enjoy themselves, though they think that's a bit old-fashioned. Now, what revolution is this going to create in the way in which standards in public life are perceived? I don't know. But if I had to ask myself what will be the most dramatic change in our lifetimes, in the lifetimes of those who come after me, for professors at university, chief executives of local authorities, heads of health trusts and the like, I would say, how are you going to deal with the consequences of communication? In the case of a doctor, the principles of confidentiality. In the case of, for the sake of argument, a chief executive, with the pressures that can be exerted. In the case of members of the National Assembly for Wales, both. All this is in a constant state of flux. And quite apart from the amazing ability of human beings to learn how to misbehave, which seems to be a constant, so too all our systems have to engage with these changes. But in the end, of course, your piece of technology is yours, private, so you believe unless somebody's hacked into it. My fundamental point is this, and I've gone on about it because I think this is the ultimate question, because, as I say, everybody knows there are some things that you simply cannot do. What may seem like private matters for you in an individual capacity, and are private matters for those who do not have public responsibilities, may nevertheless impinge adversely on the institution or organisation of which they are members or which they appear to represent. And if they don't do so in fact, they can do so through damaging perception. So how do we know when this rather difficult line, private-public, is being crossed? Well, for some, as in the National Assembly, there's a Commissioner for Standards, always available to give advice. May I be allowed again to illustrate this point from my own practicing days as a barrister. There is a code of conduct for barristers. There are occasions when, in the exercise of his profession, a barrister is required, hard to believe it for some of you, but no barrister would have any doubt about it, required to show the court material, say a decided case, which is helpful to the other side, which the other side hasn't spotted, and which will be potentially damaging to the barrister's own side. When this sort of situation arises, believe me, it's never easy, because of course you have an obligation to your client. Sometimes the answer is obvious. Yes, your duty requires you to disclose this particular case to the judge. Sometimes the decision is more subtle. I used to have a personal test, which was this. If the judge finds out next week that I hadn't disclosed this material to him, would I be embarrassed? If the answer is no, there's nothing to it. If the answer is yes, then it does not necessarily mean that you should have disclosed the material, but you should have certainly thought very long and hard about it. And if in any doubt, you should almost certainly have asked someone you trust, for him or her, to give you advice, and in choosing that person, you have to have a friend who would not always agree with you. We all have friends who will always agree with us. Find a real friend who'll say, I really think you've got to do this, which is something you don't want to do. Do we all have such a friend? I hope we all do. Sometimes, so far as the barrister is concerned, he may decide, no, I'm not going to disclose the material even if the judge would be in a rage with me next week. Because the balance I've had to strike means that I must put the interests of my client ahead of my obligation to the court. What I'm driving at is it's all very well talking about high standards in public life. When push comes to shove, on the delicate issues, on the issues where the balance is not obvious, on the issues where private-public impinge on each other, these decisions are not always easy. But there are opportunities for advice, and there are ways of testing how to respond to a problem, and in particular in the context of public life, which a barrister's profession is in the sense that it's always done in open court, there's always the media to be considered. As I've said time and again, and I never mind repeating it because I hold steadfastly to this view, an independent media is an essential ingredient of our constitutional arrangements. It's an essential part of our public life that the media should identify and expose misconduct by public officials. It's something that they're there to do. It can be very embarrassing. It can also, if they get it wrong, be very unfair. But in answering the question private-public life for those in the public eye, the test being damage to the institution that you serve, if the media found out a week later, this is not the judge now, this is the media finding out a week later about a piece of conduct by a member of the National Assembly or a chief executive, or as the case may be, and publish the story. Would that damage perception of the institution? I'm not advising, I never have advised that we should run scared of the media, but we really should recognize that the media does represent the eyes and ears of the public, and that their scrutiny represents part of the process which contributes to the maintenance of high standards and the way the public perceives the institution or organization. Big subjects, aren't they? Big subjects. Big subjects on an issue which should be clear as a pikestaff, but it isn't. The Standards Committee, of course, is the other side of the coin provided by the Commissioner. I understand that each party represented in the Assembly provides one member of the committee. I hope I don't need to underline it, and they're not here because they're in a debate, and it would be patronising if I appeared to be underlining it, which I'm not. But for you have to understand that the members of the Standards Committee are exercising, in effect, a judicial, certainly a semi-judicial responsibility. And on these issues, so far as I am concerned, as a judge, there are no party political lines. So each member must act in accordance with his or her conscience, without fear or favour, affection or ill will, just like a judge. When the conduct of the individual member is being examined, whichever party they come from, they must all be sure that the representatives of the other parties will give judgment without ill will based on political grounds, and too know that the member of the committee of his or her own party will not be moved by considerations favouring his party political colleague. These are important messages to be understood by the people of Wales. If what we are driving at is the perception of high standards in public life, somehow or other, and I have no answer to how, somehow or other we have to get them across, that there are vast numbers of people in public life in this country, and for that matter in England, who are behaving decently, with integrity, who are considering the institution they serve and its interests, who are putting their private interests behind their public obligations. That's the message we have to get across. We have to get across that isolated occasions when things go wrong are such isolated occasions, and that standards in public life have not diminished. I said I would speak. I don't think I did say I would speak briefly. I think I told the Commissioner I would speak briefly. So I'm going to stop. Just let's pause, though. However this nation develops 100 years from now, historians, we're going to look back on these decades, the first two of this century, perhaps the last few years of the last century, as the most seminal, influential period in the history of Wales for at least 500 years. I'll give you a bet with Henry VIII's dreadful Act of 1536 or Edward I's castles. But we are talking hundreds of years. The historians are going to ask themselves, what was achieved? What was not achieved? Where were the wrong turnings taken? Where are the turnings taken which have made us a happier community than we might have been? Could they have done better? Historians, of course, always know that they could have done better because they never had the responsibility of making the decisions, so perhaps could they ask themselves, could we have done better? Did this generation of the people of Wales set standards in public life that 100 years on we still respect? Did they set standards which are the envy of their neighbours? Or did they fluff a wonderful opportunity to do so? The judgment of history, of course, has yet to be made. All I can say to us today is if we keep the eye of history in mind, then we shan't let down our modern generation. Thank you very much.
So do we have a question, please? Yes, Mr. Render.
Could I ask the Chief Justice a question touching upon appellant jurisdictions exercised in Wales? We have had, of course, hearings of the Divisional Court of the Queen's Bench. I know that to my cost because I lost, and of the Court of Appeal Criminal Division. My question is whether, in your view, there should be more exercise of appellant jurisdiction within the Principality, and if your answer be in the affirmative, should that be so that it is seen to be done, or on the basis of convenience and economics?
Well, I'm not sure that's a question about standards in public life, but if you don't mind me having a go, I will. The short answer is that there's the Administrative Court sits here in Wales, the Court of Appeal Civil Division sits here in Wales to deal with cases which come from Wales through the Administrative Court in Wales. The Court of Appeal Criminal Division sits in Wales to try appeals from cases decided in courts in Wales. With this exception, occasionally, for example, if you have a sentence that's, for the sake of argument, 3 months, which means that he's going to serve 6 weeks, there isn't time to put the court together, and it's more important that the appeal should be dealt with so that if it's necessary to release the defendant at once, it can be done, rather than keep him languishing in prison, serving a sentence that, in the view of the court, is too long. So the answer effectively has to be we make arrangements for Welsh cases to be heard in Wales, and the basic rule is that all such cases should be heard in Wales. And we make arrangements in anticipation of cases which look high profile or complex, which are likely to produce an appeal at the very earliest stage to be heard in Wales. I don't think, given the current state of the national economy, and that includes Wales as well as England, that we can simply afford to have 3 judges sitting in Wales waiting with nothing much to do. We can't do it, we can't afford it, we have too much work waiting to be done. And so my answer to your question is, if you have a case from Wales which is going to the administrative court, it should always be heard in Wales. If it's going to the civil division or the criminal division of the Court of Appeal, it will be heard in Wales, unless there's a very compelling reason why not. That is how we operate the system. I hope that's an answer to your question. It may not be the answer you're expecting, but that's what I think your question was directed at.
Thank you very much. Yes, please. Can we take the microphone down the middle?
Thank you. Hello, good afternoon. Michael Draper. I belong to an institution that exists a bit down the M4, as Lord Judge probably knows. Currently, we're reviewing our policy on bribes, partially as a result of the Bribery Act, a written policy. It contains all the usual provisions: don't accept a bribe, don't offer one, corporate hospitality, disclosure of gifts, that sort of thing. But one of the things that is currently exercising our minds is a stipulation that we must not create a perception that our personal interest conflicts with our public duty. And having heard Lord Judge speak this afternoon, would you agree that is something which is entirely consistent with standards in public life and one which we should be held accountable against?
I think it's clear, isn't it, from the Nolan principles, if we go back to basics, as it were, that public and private duties are to be kept separate, and where there is conflict, the public duty, the public is the more important. And if there is conflict, then if an individual falls foul of standards and there is a question of is this public or is it private, it will be looked at as being public, because that is where we first have to stand. So I don't know whether that answers the point that you were making. Can you take the microphone?
The issue is not whether there's an actual conflict, which we all accept there is an issue, but where there is no actual conflict, but a perception has been created in the eyes of another, that somebody can still be held accountable as a result of that perception.
Forgive me, did you say where there is no actual
Even where
conflict?
there is no actual
Yes,
conflict.
well,
Yeah.
where there is no conflict, Lord Judge?
Where there is in fact no conflict, you can't be criticised. But where there is no conflict but a public perception would reveal that standards have changed, things have moved, there's a higher standard required, then the answer is that the code has to be looked at and amended. But I'm not in favour of the idea that we should be prosecuting people for criminal offences which they've committed inadvertently. That is a stage too far. I really do think so. So that's my view. If just because somebody can generate a perception, and it can be done, I mean, we've seen campaigns run in this way, X has done a dreadful thing. What X has actually done is not a dreadful thing, but is run as if it was a dreadful thing. Well, we have to be very careful not to say just because everybody thinks it's dreadful, it must have been. Occasionally things are portrayed as having been dreadful which are not. And we can't penalise people in that situation.
Claire?
I think in addition to the issue of penalties, I've been a public servant for over 35 years. I think there are duties and responsibilities that we have as public servants, whether elected to serve the public or appointed, as I have been. And the public, the people in Wales, have the right to expect the highest possible standards, and so that has to include making a judgment about what the perceptions will be of a particular action, not just whether you're entitled to do a certain thing. So, and I think all of us should take responsibility for making those judgments and that if everybody in public life did that consistently, then we would have people would have a much better, less jaundiced view of those of us who should be there to serve the public. So I think it should be, if not something that attracts penalties, an extremely clear expectation that you take account not only of what the rule book says about what's allowed, but without question, the perception of what you might do.
Thank you for your question. Yes, please.
Hello, sir. Your Lordship, my name is Alex. I'm doing a law course at the university in Pontypridd, and I had one question, if it's possible for you to answer. I'm aware of a policy decision, which was initiated on the Pontypridd County Court, which was then continued at the Cardiff Civil Justice Centre, which was also covered by the Appeals Court Civil Division in London, and which now is at the hand of the registry with the Supreme Court, and is again being, the procedures are not followed in order to make a policy that police officers cannot be prosecuted for their racist acts. So, how can I say? Is there, besides continuing the appeal at the European Court of Human Rights for the clear breaches of the Convention and the directives, is there another internal UK legislation procedure route available?
Well, if I've understood you right, the case has gone or is going through the entire judicial process in the United Kingdom up to the Supreme Court. From there, if it's a case which comes within the jurisdiction of the Luxembourg Court, that's to say the communities, it can go to the Communities Court, can be referred by the Supreme Court. If it's European Convention of Human Rights at Strasbourg, it can go there. But there's no further system. I mean, we just have a hierarchical system, and you go up the system as far as you can, and that's the end of it. There's no alternative route. So if I've understood your question, I mean, that's the route. I really can't comment on the individual case, because that's one of the things that judges aren't allowed to do.
None of us are allowed, you see, to comment on the individual cases. And of course, the purpose of this gathering is to deal with standards and not with individual cases.
This is what I was trying to say about the standards. Is it fair for a judge at a small court, at a county court, to make a decision which will bind other judges at the Supreme Court of Justice, for example?
No. The system is that the Supreme Court binds everybody, the Court of Appeal binds everybody below the Court of Appeal, the High Court judges respect each other but are not bound by it, will tend by each other, and the County Court doesn't bind anybody except the case which has been decided. They can't bind upwards, but of course the court may say, the Supreme Court may say, the County Court judge was absolutely right, he understood the principles, he applied the principles, we entirely agree with him. But that's because the Supreme Court agrees with the judge.
Thank you.
Thank you very much. Is there any other questions, please? Yes, please.
Hi, my name is Abby, and basically I was just wondering, the current code of conduct for Assembly members requires them not to do anything which would bring the Assembly into disrepute. And I was wondering, how do you decide what brings the Assembly into disrepute?
Perhaps I can ask Claire to start off with that one. What brings the Assembly into disrepute? How do we decide?
There isn't an automatic or straightforward answer, I think. It is a question of judgment, and it brings me back to what I was saying just now about perceptions. So you have to think about, has this behaviour, as was the case with one of the publicly known cases, well, both of the publicly known cases that the Standards Commissioner has reported on in his annual report today, where there was behaviour that was reported in the media and which you would expect the public generally to have frowned upon, particularly when that behaviour came from their elected representatives. So I think there are some cases where it's pretty clear that this is not behaviour that you would want to uphold as representing the reputation of the Assembly. It just, nobody could conceive that this is what the people of Wales wanted when they elected people to be representatives in the Assembly. And the two cases that we had, both involving alcohol and very poor behaviour, for me, were very clear examples of bringing the Assembly into disrepute. I think then there's a spectrum of things on which you have to make a judgment, and you know, I'm called on sometimes to make that judgment, and you then have to weigh up all the circumstances. And I might say that not all the circumstances are necessarily going to be visible to the public at large, because the media doesn't always give a full and accurate representation of the facts of the case. But as a public official and someone who has a responsibility under the standards measure to report issues to the Standards Commissioner, I have to weigh up all the facts of the case and decide on the circumstances that might not be known and the perceptions that the public, the conclusions the public are likely to draw about the members' behaviour, and is that likely to bring the Assembly into disrepute. So it's a judgment call.
It is a judgment call, and I think the rough and ready test that I will apply, as I was saying to Lord Judge a little earlier, his example of would I want the judge to know that I hadn't said something in court that perhaps I ought to have said. Would I want the judge to know that, and what if he discovered it a week later? I have sat down with Assembly members here when investigating a complaint against them and said, in relation to your conduct, the facts appear to be agreed. What would you have said if those facts had appeared in the Western Mail next Monday? Would it have caused you embarrassment? Or would you have been perfectly happy? Not perfectly happy because you have thick skin, but perfectly happy because you know you've done absolutely nothing wrong. And although it's a rough and ready test, it is the perception test. If the public would say, well, so what? Then you probably haven't brought the place into disrepute. But if the public say, that's not conduct that we expect of a member of this Assembly, that is a good guideline. Lord Judge's perception, is that all?
No, obviously, you, as I said earlier, you can't be saying somebody has misbehaved, misconducted himself, unless the evidence shows that he or she has. And it is always possible that some piece of behaviour may actually not be contravening any particular part of a code or a code of practice or whatever the case may be. Well, if that's the case, and the code of practice is out of date, you have to update the code of practice to take account of this particular feature. But we do have to be very careful not to introduce a system in which people are penalised for doing something which isn't wrong at the time when they do it.
Thank you very much for that question. Is there any other question, please? If not, I'm just going to raise one last topic and invite Lord Judge and Claire to comment on it, because it is a matter that has been raised with me, and I think it has implications for the criminal justice system too. Complaints that I deal with, I try to deal with anonymously in the first instance. We have a two-tier system, as many of you will know. I have to investigate to see whether there is material which should cause me to conduct a fuller inquiry. I make a report to the Standard of Conduct Committee, and ultimately my report will be published. If that report is critical of a member, at that stage, if not before, but certainly at that stage, the name of the member will be revealed. And so it will be known that there has been a complaint, and that probably at that stage a complaint which I at least have found to be a valid complaint. Sometimes, and I think London operate a slightly different system, they operate a system whereby onto their website goes the fact that a complaint has been made. Whatever the state of the evidence, however good or bad, And if you bear in mind that of the 24 or so complaints I get every year, perhaps 1 in 10, 1 in 12, I rule to be admissible, and the other 10 or 11 are not nonsensical in most of the cases, but they're simply not admissible because they don't deal with matters that go to breach of code. So the question really arises, because England does it one way, we do it another, and I have my strong view about it, at what stage, if at all, is it right that a member should be named because a complaint has been made against him or her? And of course it does resonate now perhaps with the criminal law, in that we've been having the argument about whether when a man is or a woman is arrested, they should be named at that stage, or they be named at the charge stage. Well, Judge, what's your view about this?
I see why you draw the analogy between arrest and charge and the situation you're describing. I myself don't adhere to the view that arrest should not be published. It seems to me there are occasions when the publication of arrest is of great importance, sometimes to the discovery of crime, sometimes to the acquittal of crime. It works both ways, so I have no problem with that. In relation to complaints against judges, the system is that, of course, everybody knows that somebody's appealing a decision, or the Attorney General is referring an unduly lenient sentence as he believes it to be to the Court of Appeal, so everybody knows that. But I don't myself think, given the number of complaints that we have which are actually without foundation because they are part of the processes rather than part of complaint about conduct, I don't see any particular reason why there should be publication of it, provided at the end of the process the clear decision that somebody has misbehaved is not concealed from the public, and the penalty that is imposed is also made public.
Claire?
First of all, to say I believe absolutely in openness, transparency and accountability. No question about that. However, in the case of complaints against Assembly members, our particular territory, I personally would not be in favour of making known the complaints at the stage the complaint is made. Partly for that same reason, that so often it's found, just reading your annual report, so often you find that either the complaints are not admissible even, or are not upheld. And I think it can do real harm to the work of an Assembly member and interrupt the flow of that work. I've seen the impact that it can make on hard-working, diligent, honest Assembly members with great integrity when a complaint is made, even if they know totally that that complaint is unfounded. I have seen the impact that that makes on individuals. And so I think that publishing automatically, immediately, is somewhat unfair, actually. I agree absolutely that having conducted the investigation, that then the public has a total right to know about the full facts of that investigation, the outcome and the penalty. No doubt about that. But I think these things need to be balanced and proportionate, and for me, publishing at the point the complaint's received would not be.
Thank you very much. I see some nods and some shakes of head in the audience. I think my practice, as I've indicated, is, although sometimes it's taken out of my hands, because I have no power to stop a complainant making their complaint public. But by and large, I deal with it as anonymously as I can, unless and until there's a finding against the member, at which point it all comes out into the open. Ladies and gentlemen, I think we'll end then the question and answer session, and I'll invite Claire Clancy just to close our proceedings.
As you've heard just now, from my bird's eye position as Chief Executive and Clerk of the Assembly, I get a close view of the work of Assembly members. I do fully support the idea that members should be exemplars of standards of conduct, both within and outside the Senedd. It is what the public expects, and I think rightly so. My team is there to support and assist members in all aspects of this. The Commission, the Assembly Commission, has provided a strong lead to other parliaments by introducing a new regime for pay and allowances that's completely transparent and subject to rigorous governance and audit. And of course, as most of you know, the Assembly passed legislation to establish an independent remuneration board that put us ahead of the game in terms of real transparency and accountability and independence on matters to do with remuneration. And of course, the same expectations in relation to standards and performance apply to the Commission and to my own teams, and I consider that to be crucially important in the work that we do. By the way, that's the bell to call members back into the chamber. They will have had a break between the emergency bill work and normal plenary, which is about to restart. So don't panic about the bell. This week, the Assembly Commission has published our annual report and accounts, and I'm proud of the achievements that that report describes. One example of that I'm going to boast about is that we achieved Investors in People IIP Gold Standard for the second time. And I think that's a testament to the work of the Commission and the staff of the Assembly and to the standards that we aspire to and that we achieve. I'd like to do two final things before I close. First, as Gerard said, the presiding officer, Rosemary Butler, is extremely sorry not to be here this afternoon. Plenary business today has been exceptional. We've had the first ever emergency bill being debated in a committee of the whole Assembly earlier this afternoon, and that meant she had to remain in the Senate. However, she's given me a message that I would like to read to you. Rosemary says, I would like to thank the Standards Commissioner for his thorough review of the Assembly's approach to standards. His report demonstrates that we are in a position of some strength in Wales, with our emphasis on openness and transparency. However, we will continue to look for ways to ensure that our conduct reflects the very best of public life in Wales. Rosemary goes on to say, I'm also very grateful to the Lord Chief Justice of England and Wales, Lord Judge, for coming to the Pierhead to deliver his lecture. Thank you for your interest in the Assembly and for making an important contribution to our thinking about standards in public life. And finally, from me, may I, Lord Judge, add my thanks to Gerard's and to Rosemary's. It was an immense privilege to listen to your lecture, and on behalf of the Assembly and our audience today, I'd like to offer you our warm thanks and appreciation.
Thank you very much.